I, a 35-year-old male, was engaged to Chloe, a 32-year-old female. We had been in a relationship for 4 years, cohabiting for 2 in my residence, which I acquired before Chloe, a detail that holds significance. The wedding is scheduled for 3 months from now, with deposits already paid and save-the-date sent out, following the standard procedure. Indeed, the majority of those deposits originated from my accounts. We engaged in a comprehensive discussion regarding finances, reaching a consensus on a combination of individual and shared contributions for household expenses. Appeared to be standard. Last Tuesday, an email arrived, not from Chloe, but from a Mr. Alistair Finch-like individual. Prenuptial agreement, Knight and Sterling. Knight represents me, while Sterling embodies her. My stomach constricted. Chloe had not brought up the topic of a prenup. Not directly. We had engaged in those vague discussions about potential scenarios, yet there was no mention of legal representation or formal contracts. I have accessed the PDF document. It wasn't merely a prenup, it was a detailed plan for my financial downfall. En hung noi kin hong chin bao gom. The assets I possessed prior to marriage, including my house and substantial investment portfolio, have remained under my ownership. Standard. Her premarital assets, including some savings and a car under loan, remained under her ownership. Understood. Understood. The shocking revelation. All assets accumulated during the marriage, regardless of who earned or acquired them, will be considered her separate property in the event of a separation. What will my future earnings be? Shopping together, all hers. I agreed to relinquish any entitlement to spousal support, regardless of the circumstances or the duration of our marriage. A provision focused on my freelance programming revenue and minor applications. All that I created during the marriage, regardless of its foundation on pre-existing ideas, would rightfully belong to her. A non-specific lifestyle clause suggesting that I would need to uphold her existing standard of living should she, for instance, determine that her marketing position no longer brings her satisfaction. The outcome was remarkably unbalanced. This did not align with the Chloe I was familiar with, or perhaps it was an aspect I had not been permitted to witness. I did not make the call to her. Finch's email explicitly indicated that all correspondence regarding this agreement must be directed through him. Understood, Alistair. The initial call was made to Sarah Miller, the attorney responsible for managing my property acquisition. I have sent the PDF. Her tone over the phone transitioned from a sense of inquiry to one of skepticism. Mark, this approach is quite assertive. Certain aspects of it are so biased that they would probably withstand a legal challenge in court. It is meticulously crafted to perfection. This marks the commencement of their strategic initiative. It is a cannonball. A lawyer is capable of drafting according to a client's requests. However, this reflects a particular perspective on their part. The impression I received was that, what is our next step? This document cannot be signed in its current form. We can attempt to reach a more equitable agreement, but be ready for them to maintain their position. This extent of overreach raises significant concerns that extend beyond financial matters. She was correct. This was not a discussion. It seemed like a request from an unfamiliar individual. On Wednesday morning, Sarah sent an email to Mr. Finch. Respectful, authoritative, yet courteous. Dear Mr. Finch, we are representing Mark Knight and have conducted a thorough review of the proposed prenuptial agreement. Mr. Knight will refrain from signing the document in its present state due to significant inequities present. We are ready to engage in a discussion aimed at reaching a fair and balanced agreement. However, this initial proposal does not serve as a suitable foundation for that conversation. On Thursday afternoon, I receive a notification on my phone. A message from Chloe, not a phone call. Chloe, my attorney informed me that you declined to sign. He understood that you did not have a genuine commitment to our relationship or the path ahead. I find it hard to trust your words. The wedding has been cancelled. In an instant, 4 years, a wedding, and the final countdown came to an end through a text message, simply because I refused to sign a document intended to leave me vulnerable. The part where he realized you weren't serious was especially frustrating. I observed it intently. The pain was genuine. A persistent discomfort. Frustration is also brewing beneath the surface. However, a profound wave of understanding emerged. This document and her response revealed a fundamental truth. I have acknowledged her message and will respond accordingly. Subsequently, I reached out to Sarah. Chloe has just called off the wedding. Through written communication. A sigh escaped her lips, yet her tone remained unperturbed. All right, Mark, let's proceed with this. What are your initial practical considerations? The deposits are under review. Location. Service provider. Photographer. Prohibited. The amount in question is approximately $28,000. All transactions are now final. All payments were made from my bank accounts. She made the decision to cancel on her own accord because I refused to sign a legal document that was unfavorable, which ultimately rendered the wedding unfeasible under her conditions. I would like to request a refund for that amount. Sarah, we can proceed with issuing a formal demand letter. She ended the agreement to marry because of an unjustifiable precondition. We will detail the foundation for her responsibility regarding the forfeited deposits. On Friday morning, Sarah dispatched another letter. This message is directed to Chloe, with a copy sent to Mr. Finch. Subject: Request for reimbursement of non-refundable wedding deposits. Knight Sterling Wedding T carefully detailed each deposit, payment date, and amount, while also providing copies of contracts that emphasized the non-refundable clauses. It was indicated that due to her cancellation of the wedding, stemming from her insistence on an unreasonable prenuptial agreement and my subsequent refusal to sign the document, she would be responsible for the resulting financial losses. We kindly request the payment of $28,000 to be completed within 20 business days. The weekend was a whirlwind of organizing Chloe's possessions from my residence. Notably minimal, primarily consisting of clothing and personal belongings. No large furniture. She had successfully removed the majority of her belongings after moving in. The subsequent week was uneventful. Excessively silent. On Wednesday, almost a week following the delivery of our demand letter, Sarah received a call from Finch. No need for alarm, simply a hint of professional irritation. Sarah informed me later that Finch had called, stating that our demand was opportunistic and that Chloe's decision to call off the wedding was a natural emotional response to your client's reluctance to ensure her future. He proposed $5,000 as a gesture of goodwill, without prejudice, to resolve this matter amicably. I informed him that such a response was not satisfactory and that we anticipated a substantial offer that accurately represents the incurred losses. The competition commences now. Update 1. 3 weeks have passed. Thank you for the messages and comments. It's reassuring to know that my feelings are justified. Following Finch's dismissive $5,000 goodwill offer, which Sarah firmly rejected, Chloe seemingly concluded that a more proactive approach was necessary. Or rather, indirect influence through her aerial assistants. Danielle, 30F, Chloe's sister and maid of honor, sent me a lengthy and self-righteous email. Mark, I find your behavior to be completely unacceptable. Chloe is in a difficult situation. All of this occurred due to your refusal to sign some standard paperwork. Alistair is an exceptional family lawyer. He was merely ensuring Chloe's safety. Are you attempting to coerce her for financial gain? You seem to be hesitant and are presenting this as a justification. All of her friends are deeply unsettled. Formal documentation. Is that correct? Sarah had previously informed me that although Finch was a recognized and assertive litigator in family law, this prenup was particularly excessive, even by those benchmarks. It seemed that the strong influence of a determined client or her family, especially her mother, was a significant factor, I suspected. Chloe subsequently sent me a direct message, bypassing the established lawyer-to-lawyer protocol through Finch. Mark, this is extraordinary. Alistair informed me that you are considering legal action? So, you were the one who hesitated to make a commitment? My parents are extremely upset. Mother indicates that it demonstrates a lack of genuine commitment on your part. I chose not to respond. Message has been forwarded to Sarah. Her concise email response has been acknowledged. Conventional strategies. Kindly remain on the line. In the subsequent week, Finch reached out to Sarah via email. He increased the offer to $10,000. Liability has yet to be acknowledged. Sarah responded by reaffirming our request for the complete amount of $28,000 and included a spreadsheet containing copies of all receipts and relevant contract clauses once more. She indicated that if a satisfactory settlement was not achieved within 10 business days, we would be required to initiate legal proceedings in district court to recover the losses. The reference to the district court, rather than small claims due to the amount involved, was intentional, indicating our readiness for a more significant legal battle, which would entail greater expenses for them in the event of a loss. Last Saturday, Chloe arrived at my residence. I was engaged in some yard work. "Chloe, Mark, it is essential that we have a discussion." She aimed for a more gentle and accommodating tone, yet the frustration was unmistakable. "Have you had the opportunity to meet Chloe? Sarah is engaging in a conversation with Alistair. This is the channel you requested." I continued to remove the weeds. No intense mower scenes. I experienced a strong emotional response. "Your refusal of the prenup put me in a difficult position. It was designed to safeguard our future." "It was crafted to safeguard your future while compromising mine, Chloe. There is a significant distinction. My parents indicated they may be open to assisting with certain wedding expenses if we can move past this and refocus on our plans." She articulated it as though presenting a significant concession. "Are we back on course? After you informed me that the wedding was cancelled due to my refusal to accept the prenup? Alistair was simply exercising due diligence. He was watching over me. I have previously mentioned my aspiration to establish my own business in the future." Her artisanal, eco-friendly pet treat business concept, often discussed after a few glasses of wine, had yet to progress beyond a Pinterest board. Was my entire financial future really meant to support that indefinitely, without any protections in place for me? "Chloe, I have completed the payment for those deposits. The wedding was cancelled due to an unreasonable demand. It is clear and uncomplicated. Is this the final outcome? Are you seriously considering legal action against me? My mother is deeply affected. She expressed that you do not align with her expectations of you. To be frank, Chloe, following that prenup, you don't align with the image I had of you anymore." She departed in a flurry of frustration. A few days later, Sarah received another email from Finch. He was now presenting an offer of $18,000. Advancement has been made, yet it remains insufficient. He expressed dissatisfaction with our rigid position and warned of a countersuit for emotional distress should we move forward with litigation, a warning Sarah recognized as mere bravado, characteristic of his approach when he finds himself at a disadvantage. The account Chloe was presenting to our mutual friends suggested that I led a concealed financial existence and was unwilling to be open, which justified the necessity for the protective prenup. The defamation was becoming increasingly inventive. Sarah noted that Finch's escalating offers, notwithstanding the bravado, suggested a preference to circumvent formal legal proceedings. He was assessing our determination. We provided him with our ultimate deadline. The total amount is required, or we will proceed with filing. Cap Not 2. 3 weeks later, the deadline for the $28,000 had elapsed. Finch's final proposal amounted to $22,000, presented with language that absolves any liability. Sarah promptly initiated the lawsuit in district court the following day. We presented a compelling case regarding the breach of contract, specifically the agreement to marry, which was undermined by an unreasonable last-minute demand. The process server served the summons to Chloe at her parents' residence, where she was temporarily staying a few days later. This, it seems, is when the meticulously built facade of the Sterling family's privilege began to reveal significant flaws. It was not immediate, with no frantic calls in the following hours. However, approximately 3 days after Chloe was served, Sarah received a call from Mr. Finch. She noted that his tone was noticeably less assured than it had been previously. "Finch, Ms. Miller, my client, is fully prepared to robustly defend this suit. In order to prevent lengthy and expensive legal proceedings for everyone involved, we are willing to engage in a more thorough discussion regarding settlement options. Mr. Finch, our stance has been unequivocal. The responsibility for the $28,000 in non-refundable deposits rests with your client. We remain receptive to a resolution that accurately represents the current circumstances." In the following week, a series of emails and calls transpired between Sarah and Finch. Finch attempted to negotiate a reduction in the amount, referencing the mutual accountability for the wedding's dissolution. Sarah maintained her position, emphasizing that the prenup was the only factor instigated by his client. Subsequently, there was a development that I became aware of only at a later time. Chloe's father, Bill, who had mostly remained in the background, a reserved and unassuming individual, seemed to have taken a decisive stand. An acquaintance, who had a friendly relationship with a cousin of the Sterling family, informed me that Bill, after reviewing the court summons and likely discussing the potential expenses of an unfavorable outcome in district court with a more pragmatic Finch, who would have needed to clarify the risks to his clients, conveyed to Karen, Chloe's mother, and Chloe that the situation had reached its limit. He may not have been affluent, but he held their family's reputation in high regard and was determined to avoid a contentious public lawsuit that they were likely to lose. He instructed Finch to address this matter thoughtfully and promptly. The pressure behind the scenes likely accounts for Finch's subsequent call to Sarah. Finch, Ms. Miller, my clients are ready to present a complete offer of $28,000 to resolve this issue, contingent upon Mr. Knight's acceptance of a mutual non-disparagement clause and the withdrawal of the lawsuit upon receipt of the funds. We kindly request reimbursement for our filing fees and related service costs, Mr. Finch. Under the current conditions, the amount is $650, which encompasses the actual court filing fees, process server costs, and a portion of the initial paralegal time dedicated to preparation. Finch, I will verify that with my client, but I am confident we can proceed accordingly. He returned the call within a few hours. They reached a consensus. Certified funds amounting to $28,650 are to be delivered within 5 business days, accompanied by the settlement agreement. The check was received yesterday. The agreement, which has been duly signed by Chloe, encompasses the non-disparagement clause. This morning, I visited Sarah's office and completed my portion of the paperwork. She is submitting the withdrawal notice. The task has been completed. The effort to corner me with that prenup, the dismissal of the text message, the sense of entitlement, all met with a wall of composed, systematic legal pressure. No loud arguments, no theatrical confrontations from my side, just a clear and steady position. Chloe's sister, Danielle, sent one final email with a pointed remark. I trust you are feeling confident and positive about yourself, Mark. Chloe is deeply affected, and this entire situation has placed significant strain on our family, all due to a financial matter. I have archived it without a response. Certain individuals may remain confined within their own perspective. The true achievement goes beyond mere financial gain. It serves as a subtle affirmation that I maintained my position in the face of a deliberate effort to diminish my standing. They assumed I would succumb to emotional pressure or be intimidated by the legal battle. They made an error in judgment. The ownership of my house remains with me. My future earnings are guaranteed. The assurance of having avoided that danger is the true resolution. It's a relief to see that gone.